Mm.
In docket 24035510. That is people of the state of Michigan versus Caleb Ray. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Robinson.
Karen Robinson, Assistant Public Defender for Mr. Ray.
And sir, you are Caleb Ray, is that correct?
Yes, sir.
All right, thank you. This is the time set for a preliminary examination. Ms. Wilson, how we proceed?
Thank you, Your Honor. It's my understanding that this is going to be a plea to an added count or an amended count one, however the court wants to do it, to use of a controlled substance, namely a narcotic, cocaine. That is a 1-year misdemeanor and or 2,000, and there is a sentencing agreement to no upfront jail, and the people have no objection to 7411 status should the defendant be eligible.
And no objection to 74.
And I have the PAC code whenever the court's ready.
All right, so I've been meaning to ask this a long time. Do we prefer an added count two or amended count one?
So for my purposes, I have no preference. It's my understanding the clerk's office has a preference, and I've never been able to nail down what it is.
Amend?
Amend,
right.
Okay.
I guess I've never asked that after almost 3 years. Okay, so amend to use of cocaine or controlled substance. And what's the PAC code?
333.74042A.
And that's a 1 year and or 1,000?
2,000.
All right, so Ms. Robinson, I'll reiterate my understanding of the negotiations. It's a plea to the amended count one of use of cocaine under 333.74042(1)A. It's a 1 year and or $2,000. There's a kilobrute and no upfront jail, and there's no objection by the Ingham County Prosecutor's Office to 7411 status. Is that your understanding?
That's correct.
All right. Mr. Ray, you understand that there's an agreement between the attorneys that there's no upfront jail in this matter. If I was going to do something different than that agreement, you'd have the opportunity to withdraw your plea. Do you understand that, sir?
Yes, sir.
All right, thank you. May I inquire, Ms. Robinson, of your client of his advice and misdemeanor rights?
Yes.
So you understand, sir, that you are the use of cocaine has a penalty of 1 year and or $2,000, and you have the following trial rights in this matter, and I'll walk you through those. All right. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by attorney Erin Robinson. She would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir? You have the right to have the court order any witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If you plead as accepted, you'll give up the claim the plea was a result of any promises other than what's been stated on the record or threats that it was not your choice to plead guilty. You'll also be giving up the right to appeal any issues from a trial. Since you won't be having a trial, you'll be pleading guilty instead. Is it your wish today to waive your jury trial rights and plead guilty to the offense of the use of cocaine?
Yes.
All right. All right. I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
All right. I'm going to bring your attention back to November 28, 2024 at the offense location of 314 Westmoreland Avenue in the city of Lansing, Ingham County. were you at 314 Westmoreland in the city of Lansing on November 28, 2024? And at that time, did you use a narcotic that you understood? Did you knowingly use a narcotic that had a mixture containing cocaine in it? And that wasn't an accident used on purpose. Anything for the factual basis, Ms. Wilson?
Mr. Ray, you knew that it was a controlled substance when you used it, is that correct?
Did you know it was cocaine?
Okay, nothing further, Your Honor.
All right. Ms. Robinson, anything towards the factual basis?
No, Your Honor.
I find the factual basis to be knowing, voluntarily, accurately made, and we will refer to probation. All right, so the 5th floor is where probation is. Go down to the 5th floor and then they'll either set up an appointment or see you directly. And what they'll do is they'll put a report together for me, all right? And then we'll see what options we have at sentencing. And the sentencing date is?
February 13th at 8:30.
February 13th at 8:30. All the conditions still remain. And I will see you on February 13th at 8:30 once I get a pre-sentence report. All right, sir? Anything else for the record in 2403510, Ms. Wilson?
Not for the people.
Ms. Robinson?
No, Your Honor, thank you.
You're all set, Mr. Ray. We'll see you on the 13th.
You said go down to the 5th.
Yep.
Yeah.
Judge, I'm gonna go get blue.
All right. Blue, James Blue?
Correct.
Okay.
Go ahead.
Well, do you have anyone else? We've got Mr. Sartz is here for Mr. Blue, I would assume.
Yes,
And we're on this.
more.
Tracy Moore?
Yes, and that's gonna be a misdemeanor
Mr.
plate.
Mouch.
Probably, yes.
All right. So,
She's on Zoom.
Miss Tracy Moore. I don't see Tracy Moore on this.
We had put her in a breakout room.
Okay, let me move her
Now
over.
we need to pop her back.
Then Ms. Schroeder, you have Mr. Anthony.
Yes, Your Honor.
All right,
Maybe.
We're
negotiations are continuing. Are we, that might be this afternoon?
That's the one where he's possibly in Livingston,
Okay.
so she's actually here. Yeah. Um,
I was gonna ask if you could PR mine. Or the number.
and if you wanna ask for.
So Ms. Moore back in.
No, when I moved her, but it takes some time, but
Okay.
it's-
Okay, correct. Yeah.
Adjust her back. He wants.
Perfect. Your Honor, if Mr. Anthony gets on Zoom to do a waiver, will you accept it?
yes,
Okay,
Thank you.
perfect.
All right, I will get him the Zoom ID.
yes. For a waiver, yes, no, I will regardless, but Mr. Moore, but Miss Moore, I don't know if she's at her phone or, I don't know if she has to, she's just not coming over.
Interesting, okay. I'm just gonna go release my officers on Anthony real quick. Yeah. Works for me.
Mr. Wilson, do you want to wait to see if Mr. Anthony joins us before
Yeah, that's probably a good
the
idea.
release,
Yeah.
just in case?
Yeah.
I was
Because
gonna,
we haven't been joined by Mr. Anthony yet.
That's probably. a good
Yeah, I
idea.
gotta get him his, the ID.
Yeah. And I can't get Miss Moore over.
I think Mr. Mouch.
What?
Perhaps contact your client to see if
Yes.
we're assuming to have a technical.
Good luck with Or I don't know. I just can't get her over here. Could be Zoom. My garage door didn't work this morning.
Yeah,
It
yeah.
could be just cold. I don't know. I don't know.
Just let me join and see if I can do anything to help.
I'm not saying it's Miss Moore's fault because everything could be working a little slower today.
Definitely is moving slow. When you pop me into Zoom, you co-host,
What are you gonna do?
I'm gonna try to put her in a different breakout room and move her back to the main session. Or you can do that. I don't know why I
don't
went
know.
that
I don't
route.
know.
Sometimes if you put them in a different room and then bring them back to the main session, or maybe close the room, sometimes that forces people.
Let's
I don't
try
know.
She's not leaving room 1. Oh, she's in room 3. I think that worked.
Okay.
I think.
So, just trying to help.
Yeah, that did work.
Those are the only tricks I
That'll
learned.
work. That'll work.
Yeah, never mind. I don't need to be anywhere near Zoom. I'm out.
So we do have Tracy Moore here.
Perfect.
I think. Miss Moore, you can unmute. Miss Moore, you can unmute and we'll call your case. All
hear
right, perfect. We can. All right. So we're on the record in 24-03-182. That is people of the state of Michigan versus Tracy Moore. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Mr. Milks.
And good morning, Your Honor. Stephen Milks on behalf of Ms. Moore. Ms. Moore, with permission of the court, is appearing via Zoom at this time.
And ma'am, you are Tracy Moore, is that correct?
Yes,
And you can hear me all right, Ms. Moore?
yes.
All right, this is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that this is going to be a plea to 2 added counts, an added count of malicious destruction of a building under $200 and an added count of entry without permission. Both are 93 days and or 500. Upon successful plea and sentencing, count 1 would be dismissed.
All right, so there'll be an added count 2 of
Malicious destruction of a building under 200.
MDOP. That'd be MDOB
Yep,
under $200. That's a 90-day and or
93 and or 500.
93 and or $500. And then account 3 of
Entry without permission.
entry without permission. That's a 90
penalty,
and or
yep.
$500. All right.
And I do have the PAC codes for both of them.
All right, what's the PAC code on the MDOB?
750.3805.
All right, and on the entry without permission?
750.115-A.
And with a successful count 1 is to be dismissed upon successful plea and sentence.
Correct.
And Mr. Milks, is that your understanding of the plea agreement?
Yes, Your Honor, that is a complete recitation of it.
All right, and Ms. Moore, that's your understanding, is that correct?
Yes.
All right,
Yes.
Mr. Milks, may I inquire of your client of their advice of rights on the 2 misdemeanor counts?
Yes, and thank you, Your Honor.
All right, Ms. Moore, you understand that you have a right. I'm going to read you your rights on counts 2 and 3. They're both misdemeanor counts of 93 days and or $500. And you have the following jury trial rights concerning both those matters. All right, ma'am? You have the right to be tried by a jury, to be presumed innocent or proven guilty, to have the prosecutor prove beyond unreasonable doubt that you are guilty, to have the witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by attorney Stephen Milks, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, ma'am?
Yes.
You have the right to have the court order any witnesses appear in your defense, remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give the claim the plea was a result of any promises other than what's been stated on the record or threats that it was not your choice to plead guilty. You'd also giving up the right to any trial on these issues. Since you won't be having a trial, you'll be pleading guilty instead. Is it your wish today to plead guilty to the added counts 2 of malicious destruction of building under $200 and count 3 of entry without permission, entry without the owner's permission?
Yes.
All right. I'm gonna have you raise your right hand as best you can, ma'am. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
All right, I'm gonna bring your attention back to August 26, 2024, at the offense location of 3213 Boston Boulevard, City of Lansing, Ingham County. Were you at Boston Boulevard in the City of Lansing, Ingham County on August 26, 2024?
Yes.
And at that time, did you intentionally cause damage to a building under $200?
Yes.
All right, and that wasn't by accident. You did so with the intent to do damage to the building. Is that correct?
Better maybe
Not
inquire specific.
Go ahead.
May I inquire specific?
damage, but
All right, so Ms. Moore, kind of as we talked about, you were at that house, that location, is that correct?
yes.
And you did break a window, isn't that correct?
Yes.
And you intended to break that window, is that also true?
Yes.
All right, and it was with that entry, with that window through which you gained entry into the house, is that correct?
Yes.
Okay. And while in the house, you also knocked over some property and you did that on purpose, is that correct?
Yes.
Okay, and the damage, you did that on purpose, correct?
Yes.
All right. And while you were in the house, did you have permission to enter the house?
No.
Okay.
All right. Anything towards a factual basis, Ms. Wilson? I think that covers it.
Just one extra question. Ms. Moore, you knew at that time that you did not have permission to enter that home, correct?
Yes.
Okay, nothing further, Your Honor.
Mr. Milks, anything towards a factual basis based on some of your questions?
No, thank you, sir.
All right. I find the factual basis for count 2, malicious destruction of building under $200, and count 3, the entry without permission at the same locale. And all this happened on count 2 on Boston Boulevard in the city of Lansing on that August 26th date. Is that correct, ma'am? On count 2, the entry without permission?
Talking to me, Tracy?
Yeah, I'm talking
Yeah.
to you, Ms. Moore.
Yes.
Okay.
Yes.
Thank you. All right. So I think that the venue and the location have been set in the city of Lansing for Ingham County on count 3 also. So I will indicate that that has been knowing, voluntarily, and accurately made. And will refer to probation. So Ms. Moore, you have 48 hours. So I'd say Monday, right? By Monday, I think they close at 4. By Monday at 4 to get to the 5th floor of probation in the City Hall building so that they can start meeting with you, take a meeting. You might want to call before you get to see if maybe they'll just set up a meeting date. But they're going to do a report for me, and then that report will be used to see what options are available to us in sentence. All right, ma'am?
Yes.
So you should contact them and be available to them by Monday, and we will set sentencing date for
February 13th at 9.
February 13th
Yes.
at 9 a.m. So sentencing is set for February 13th at 9 a.m. But probation will seek to have you answer questions or meet with them by at least Monday. Be in contact with them, and you'll get the sentencing date sent to your West 8 Mile Road address in Detroit. All right, ma'am?
Yes.
All right. Anything else for the record in 2403182, Ms. Wilson?
Not for the people.
Mr. Milks?
Now for the defense, thank you.
All right, Ms. Moore, you're all set. We'll see you on that February 13th date.
At 124 West Michigan Avenue.
Yeah, it's what was that, the
The
address?
court address,
The
yes.
court address, yes.
West Avenue, 5th floor.
Yeah, 124 West Michigan Avenue, right across from the Capitol.
Okay.
You're all set, ma'am.
Thank you. Y'all have a good day.
You too.
It's Monday.
All right, so we're on the record in docket 24-03505. That is people of the state of Michigan versus James Blue. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Sarks.
Good morning, Your Honor. Jacob Sark, support Assistant Public Defender here on behalf of Mr. Blue, the eighth. He's present at council table. He's staying in my right.
And sir, you are James Blue the eighth, is that correct?
Yes, sir.
Thank you. This is the time set for I have it both set for preliminary examination and a PA 53 violation. Ms. Wilson, how are we proceeding today?
Thank you, Your Honor. It's my understanding that the defendant will be unconditionally waiving his right to a preliminary exam with an added count of witness interference. The people also unconditionally waive their right to preliminary exam. We request bind over with that added count. And at this point, we'd be moving to dismiss the PA 53.
Okay. So the waiver of the preliminary examination with an added count. And I'll make sure that,
Be an added count 3, I believe.
all right, an added count 3 of witness intimidation.
That's a 4-year and or 5,000.
Do you have a pack code for
I
that?
do. It's 750.1227A.
And is that a fair statement of Mr. Sartz, the waiver and with the added count 3?
That's correct, Your Honor. Thank you.
All right. May I inquire of Mr. Blue of his waiver of the preliminary examination?
Please, Your Honor. Thank you.
Mr. Blue, you understand you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You were represented today by Attorney Jacob Sartz, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish today to waive your right to a preliminary examination on counts 1 and 2 and the added count 3 of witness intimidation. Have these negotiations continue in circuit court where this case will proceed. Is it your wish today to waive your right to a preliminary examination today?
Yes.
Ms. Wilson, do the people also waive their right to a preliminary examination?
We do, Your Honor. Thank you.
All right. I find that the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And I will provide the documentation for bind over. This is a little different. But I will. We don't have, with the understanding that on the record, I don't see it here that we have a new place to sign it. But that is bound over with the added count 3 of witness intimidation. All right. So it's just a little different.
Yeah, I know this tonight was part of it.
It's a
but
little
that one was
different.
different.
Yeah. So,
I don't even think there was a place to put the bond.
yeah, it's just a, there's a bind over and it's just formatted different. All right, so I'll provide the bind over documentation for signature.
Yeah, I'm just gonna see them in this one.
Thank you, Ms. Laviak. I am in possession of the bind over documentation signed by both council on 24-03-505. I'm going to indicate that the examination has been waived on today's date, which would be 12/20/2024. It's on the amended charges. I'm going to add, I didn't see it here in small print. I'm going to add the count 3 of witness intimidation, so there's no misunderstanding. My adding would probably cause some misunderstanding. 750.1227A. Anything besides, before I sign the bind over documentation on 24-03-505, Ms. Wilson.
Half of the people.
Mr. Sarks.
Nothing further, Your Honor. Thank you.
All right, Mr. Blue, your time in district court is done here. You're on the circuit court. Will you get your next date from your attorney, Mr. Sarks? All right.
Yes, sir.
I'm going to sign the bind over documentation. And you should be all set, sir. Thank you for your appearance today.
Thank you, Your Honor.
Thank you, Mr. Sarks. Oh, let's go ahead and dismiss that other one too. So the PA 53 is dismissed for
Yes,
purposes.
yeah.
of
Yeah,
this.
Nancy Hamilton just emailed me that. Yeah. Mhm. Do you know where he's gonna end up yet?
From the regular
Okay.
first, and then eventually they'll be transferred.
Okay.
We'll probably be-
Yeah, she's not there, and I was also thinking if we wanted to amend it, I want to. Kids, so I wanted to amend it to third party to. Like, I think for like, if the mom specifically is not a violation, but I'd rather have something in writing so that we don't. Yeah, so I'm ready on that one if you are. And then we're ready on Bruce.
Thomas Bruce. All right, so we're on the record in docket 24-03-294. That is People of the State of Michigan versus Thomas Bruce. Appearances for the record, Ms. Wilson.
Abigail Wilson for the people.
Mr. Goodrich.
And Luke Goodrich from the Public Defender's Office, here to represent Mr. Bruce, who's standing to my right today.
And sir, you are Thomas Bruce, is that correct?
That is correct, Your Honor.
Thank you. This is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that this is going to be a plea to count 2 domestic violence. Upon successful plea and sentencing, count 1 is to be dismissed. There is a sentencing agreement to no further upfront jail. And the people have no objection to 7694A status should the defendant be eligible.
And no objection to 769 for a status.
Yeah.
That is a plea to the count 2, right?
Correct,
And count 1 is to be dismissed upon successful plea and sentence.
correct. And it's my understanding that the factual basis is going to be more for count 1.
Okay. And is that a fair and full and accurate statement, Mr. Goodrich? It's going to be a plea to count 2, to domestic violence with a factual basis to count 1, a higher charge. That there's a Killebrew agreement of no upfront jail. There's no objection to 769 for a status if available, and count 1 is to be dismissed upon successful plea and sentence.
That is correct, Your
All
Honor.
right. May I inquire of your client, Mr. Bruce, of his misdemeanor rights?
Yes, Your Honor.
Thank you. Mr. Bruce, you understand that you'll be pleading, you'll be using a factual basis for the interference of electronic communications, but that will result in a conviction for domestic violence which is punishable by 93 days and or $500. Do you understand that, sir?
Yes.
There's an agreement between the attorneys that you serve no further upfront jail. And if I was going to do something different than that agreement, you'd have the opportunity to withdraw your plea. Do you understand that, sir?
Yes, sir.
There's also no objection from the prosecutor to 769 4A status if it is available. Do you understand that?
Yes.
All right. You understand you have the following jury trial rights in this misdemeanor plea. You have the right to be tried by a jury, to be presumed innocent until proven guilty. Have the prosecutor prove beyond a reasonable doubt that you are guilty. Have witnesses against you appear at trial. The questioning witnesses that are brought against you. You are represented today by attorney Luke Goodrich, who would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
Yes, sir.
You have the right to have the court order any witnesses appear in your defense to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give the claim the plea was a result of any promises other than what's been stated on the record or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading guilty to count 2, the domestic violence misdemeanor. Is it your wish today to waive your jury trial rights and plead guilty to the domestic violence misdemeanor?
Yes, sir.
All right. I'm going to bring your attention back to October 29, 2024 at the offense location of 73 Parkway Drive, City of Lansing, Ingham County. Were you present in Lansing at 732 Parkway Drive on October 29, 2024?
Yes, sir.
And at that time, did you purposely, willfully, knowingly prevent or delay any interference through Cheyenne Bruce through a telephone or telephone line communication?
Yes, sir.
Tell me what you did.
So we were arguing and she was calling. I didn't know who she was gonna call, if it was family or the police, and I grabbed the phone from her hand and in doing so kind of tugged on her arm.
All right. And when you grabbed the phone, you did so to prevent her from calling someone.
That is correct.
Anything towards a factual basis, Ms. Wilson?
No, Your Honor, the people are satisfied.
Mr. Goodrich?
Your Honor, I believe we do need to establish that Cheyenne Bruce is your wife, correct?
That is correct.
Okay, all right. But for count 1, the plea was made for count 1, but I think that's additional information. All right. So I find the plea to count 1, the higher count, indicates that it was successful for count 2, which is the 93-day misdemeanor, and I'll accept the factual basis as knowing, voluntarily, and accurately made. We will refer to probation. So, Mr. Bruce, you should go down to the 5th floor when we're done here, and they'll either set up a time or see you. They're going to prepare a report for me, and then we'll see what options are available to us at sentencing. All right, sir?
Yes, sir.
All right. We'll set sentencing for
December 13th at 9:30.
so December 13th.
I'm sorry, February
I was like,
13th.
whoa.
Oh,
Oh, I'm so sorry, February 13th.
February 13th at 9:30. All right, so be back here live in person on the 6th floor, February 13th at 9:30, and we'll see what options are available to us at sentencing. All right, sir?
Yes, sir.
Anything else for the record on 24-03294, Ms. Wilson?
Yes, Your Honor, there is a joint request for a bond modification from both the people in the defense in this matter.
Okay.
Currently, the way the bond reads, Mr. Bruce is not allowed to return back to the address that this incident occurred at. I have received confirmation that the victim no longer resides at that address.
All right.
So the First Amendment we'd be requesting is that he be allowed to return to that address.
And that's a fair statement, Mr. Goodrich?
Yes, Your Honor.
So defendant is allowed to return to address, and that would be 732 Parkway Drive.
I believe so.
Yes.
And that's Lansing 48910. And such return would not put him in violation of the no contact order.
Correct.
So that would not, so I think that's safe. There's still a no contact order, but that would put him in violation.
And as to the no contact order, that's the other amendment that we're requesting. There are shared children in this matter. And I've spoken with the victim and she has requested that there be some kind of amendment to the bond condition to allow for third parties so that Mr. Bruce can talk to his children.
All
It's
right.
already up.
Oh, is it already in
I
there?
think it
Oh,
is.
okay.
So
My bad.
I have initially written, and I'll state this for the record, third-party contact is allowable to the two minor children.
That's
Perfect.
the
And
computer.
that's from the magistrate. All right.
Perfect. Never
So
mind then.
no, that clarifies that you can have contact with the minor children as long as any contact has the third-party supervision. All right, sir?
So does that mean that like my mom or dad has to reach out to her family? I
Correct.
can't personally reach out to her.
Correct. So your mom, for our purposes, your mom and dad could have indirect contact with her for purposes of contact with the minor children.
Okay.
All right.
Thank you.
You're welcome. Anything else for the record on 2403-294, Ms. Wilson?
Not for the people.
Mr. Goodrich?
No, Your Honor.
All right, Mr. Bruce, we'll see you on that February 13th date. Thank you for your appearance today.
Thank you.
Okay, thank you, Your Honor.
Here's that number for you.
Is there anything?
Okay, we might need to check about if we need to update anything. Yeah. And then we have to spend it all.
Ms. Mendenhall,
Legally, right?
do we need to get Ms. Mendenhall?
No, she's here.
All right. Ms. Mendenhall, you come on.
Speedy today, John.
You are speedy today. Stop that. And do you need a second to confer with your client, Mr. Sarts?
Oh, we're ready to go, Your Honor. I'm just getting an advice of rights. So don't
Okay.
forget that he's in a few pages now.
All right, so we're on the record in docket 240351. That is people of the state of Michigan versus Paris Mendenhall. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Mr. Sarts.
Good morning, Your Honor. Jacob Sarts, the fourth Assistant Public Defender here on behalf of Ms. Paris Mendenhall. She's at council table. She is standing to my right.
And ma'am, you are Paris Mendenhall, is that correct?
Yes, Your Honor.
All right, thank you. This is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that this is going to be a plea to an amended count 2 of use of a controlled substance. That is a 1 year and/or 2,000. There is no objection to 7411 status should the defendant be eligible.
Okay, so plead to the amended count 2 of use.
Correct. And upon successful plea and sentencing, count 1 would be dismissed.
And that is a 1 year and or
2,000.
2,000. And you have a pack code for
I
that
do.
again?
Yes, it's 333.74042A.
Is there, you probably indicated, is there any other sentence agreement on this?
So originally, there was a sentencing agreement to no further upfront jail. However, Ms. Mendenhall is currently serving a 120-day sentence out of circuit court. So I think at this point, that isn't really an option. But I would defer to Mr. Sarts on that.
Thank you, Your Honor. I would just ask for credit for time served at the time of sentencing.
And I would assume that has she made bond on this?
No, she was PR bond, Your Honor.
Does she want like a small bond to to start tolling this time?
Yes, Your Honor, so she can earn credit.
Yeah.
A small 5% bond, or excuse me,
Alright, so-
10% bond. And Your Honor may approach, I have the advice right.
Absolutely.
Thank you.
Thank you, Mr. Sarks.
Thank you, Your Honor.
All right, so we'll address bond after the plea is taken, so that the defendant, Ms. Mendenhall, is accumulating the correct time for this offense. And Mr. Sarts, I can address the advice of rights concerning your client.
Yes, please, Your Honor. Thank
All
you.
right. Ms. Mendenhall, you've given the court an advice of rights concerning the 12 rights that you're waiving in regards to the misdemeanor plea of use of cocaine. And you've signed this advice of rights. Is that a fair statement, ma'am?
Yes, Your Honor.
All right. And I'll just cover the three main ones. You understand you have a right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to silence in this matter, and you have the right to choose to testify if you want to testify in this matter. Do you understand that, ma'am?
Yes, sir.
All right. You also have the right to counsel. You have the right to Mr. Sarts present, and Mr. Sarts is present to cross-examine any witnesses or contest any charges brought against you by the people. Do you understand that?
Yes, Your Honor.
If your plea was accepted, you'll give the claim the plea was a result of any promises other than what's stated on the record or threats that it was not your choice to plead guilty. It also giving up the right to appeal anything from a guilty verdict. Since you won't be having a trial, you'll be pleading guilty to the use of cocaine misdemeanor instead. Is it your wish today to plead guilty to the use of cocaine misdemeanor, that being 1 year and or $2,000?
Yes, Your Honor.
All right. I'm going to have you raise your right hand. Do you solemnly swear or affirm as best you can, ma'am? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right. I'm going to bring your attention, ma'am, back to November 27, 2024 at the offense location of 921 West Holmes Road in the city of Lansing, Ingham County. Were you present on November 27, 2024 at 921 West Holmes Road in the city of Lansing, Ingham County?
Yes, sir.
And at that time, did you knowingly use the controlled substance of cocaine?
It would be heroin, Your Honor.
Okay, heroin.
Thank you.
Did you knowingly use the controlled substance of heroin?
Yes.
All right. And you knew it was heroin when you were using it?
Yes. Yes,
Oh,
Your Honor.
all right. Anything towards the factual basis, Ms. Wilson,
Not for the people.
Mr. Sarks?
Thank you, Your Honor. Just briefly, Ms. Mendenhall, you would have no legal reason why you would be able to use heroin. You understood it was an illegal drug when you were using it at the time, correct?
Yes, Your Honor.
Thank you.
Yes, sir.
Thank you.
All right. I find the factual basis to be knowing, voluntarily, and accurately made, and will refer to probation for the pre-sentence. So probation will be there to see, will probably come to see you, Ms. Mendenhall. And we'll set sentencing for
13th of April.
February 13th at 8:30.
8:30.
8:30. And then at this time, we will set a bond in this matter for $4,000, 10%. That should have it start accumulating anytime. And so probation will be down to see you, and we'll see what options are available to us on February 13th at 8:30 once a pre-sentence done for myself. All right, ma'am?
Yes, Your Honor.
Anything else for the record in 24-03511, Ms. Wilson,
Not for the people.
Mr. Sarks?
Nothing further, Your Honor.
Thank you. All right, Ms. Mendenhall, you're all set. Thank you for your appearance today.
Thank you. You guys be safe out there.
You too.
All Welsh. Yeah. Your Honor, if Mr. Etheridge and I could approach on a question of the case.
Sure. Right, on the iPhone 1001-2024, we just let you into the Zoom courtroom. Can you identify yourself? You'll have to unmute. What's your name? What's your name, sir? You have to unmute. We didn't hear your name, so you have to unmute. Oh, you almost unmuted there. What's your name?
Maurice Anthony.
Maurice Anthony. All right. So, Mr. Anthony, stand by. You're in the right place. And we're going to call a case in front of you. I'm going to rename you. All right. So, Mr. Anthony, stand by. I'm going to call a case right in front of you, and then we'll call your case. All right. So we're on the record in 24-03513. That is People of the State of Michigan versus Jatavian Javon Embry. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Robinson.
Aaron Robinson, Assistant Public Defender for Mr. Embry.
And sir, you are Jatavian Embry, is that correct? Thank you. This is the time set for a pretrial in the matter, a preliminary examination in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that this is going to be a plea to count 3, that's operating a motor vehicle without security, and count 4, that's operating while a license is suspended, revoked, or denied.
All right, and those are already.
Those are already charged.
I'll say, so a plea to count 3 and count 4.
And upon successful plea and sentencing, the balance would be dismissed.
Thanks, man. Stop it.
Mr. Anthony, you should stop talking or mute because we can hear everything you're saying.
Oh, I'm sorry. My dog jumped on me. I'm sorry.
All right. So that would be counts 1, 2, and 5. Is that right?
No, just
Or counts
For the
for the
dismissal.
for the dismissal?
Yes,
Okay.
yes, yeah. And just for clarity purposes, I have count 1 as an RNO, count 2 as an RNO, and count 5 as operating an unregistered vehicle.
I do too. Was this all right? All right. So, Ms. Robinson, that's your understanding. A plea to count 3 and 4 upon a successful plea and sentence, counts 1, 2, and 5 would be dismissed.
correct.
All right. May I inquire of your client, Mr. Embry, of his advice of misdemeanor rights?
You may.
All right, Mr. Embry, you understand that each of these misdemeanor pleas, count 3, motor vehicle operation without security, comes with a penalty of not more than 1 year or not less than $200, and count 4 comes with is a misdemeanor plea of 93 days and or $500. You understand those are the potential penalties in this matter. You understand that? All right, thank you. In each of these misdemeanor jury trial rights, I'll walk you through those. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by attorney Aaron Robinson. She would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir? Is that a yes?
Yes, sir.
All right, thank you. You have the right to have the court ordering witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what we put on the record, or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from a trial. Since you won't be having a trial, you'll be pleading guilty to the counts 3 and 4 misdemeanor counts instead. Is it still your wish today to plead guilty to counts 3 and 4 of the plea agreement today?
Yes, sir.
All right. I'm gonna have you raise your right hand. Do you solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right. I'm gonna bring your attention back to November 29th, 2024, at the offense location of South Washington and West Hodge in the city of Lansing. were you operating a motor vehicle open to the general public on South Washington, West Hodge in the city of Lansing?
Yes, Your Honor.
Okay. And that was a Chrysler automobile?
Yes, Your Honor.
Okay. And at the time you were operating the Chrysler automobile, is it true that you did not have insurance on that vehicle? Okay. And in count 4, at the time you were operating the Chrysler vehicle, that you were stopped by law enforcement and you did not have your operator's license had been suspended, revoked, or denied at that time. Okay. And you knew that when you were driving. Is that a yes?
Yes, sir.
All right, thank you. Anything towards a factual basis, Ms. Wilson?
Not for the people.
Ms. Robinson?
No, Your Honor, thank you.
I find the factual basis on counts 3 and 4 to be knowing, voluntarily, and accurately made. Will be dismissing counts 1, 2, and 5 upon successful plea and sentencing. Did you want this referred to probation?
I think we're gonna go with immediate sentencing.
Okay. So and is that a fair statement, Ms. Robinson?
Yes, we'd be requesting immediate sentencing, Judge.
All right, so immediate sentencing on the file, allocution, Ms. Robinson.
Yes, Your Honor, we'd ask that you sentence Mr. Embry to fines and costs for this case, it being a driving case.
Counts 3 and 4 are both driving offenses. Ms. Wilson.
Thank you, Your Honor. I think fines and costs are appropriate given the circumstances.
All right. So Mr. Embry, is there anything you'd like to say to the court before the court passes sentence on both of these misdemeanor driving offenses? All right. So I will follow the recommendation set by counsel and indicate no jail on counts 3 and 4. The operating without security count, so it's count 3. So we'll have a fine of 150, cost of 150, crime victims' rights of $75, state fee of $50. Is there any restitution on this matter, Ms. Wilson?
There's not, Your Honor.
All right. So I'll give you a total on that count. That's count 3. That'll be 300 plus 75 plus 50 is 425. And then on count 4, which is the driving while license suspended, we'll set a fine of $100, cost of $100. I'll waive the crime victims' rights fee and the state fee on that. For a grand total of $200. So that'll be $625 to the city of Lansing. Does your client need some time to make that payment?
He does. We'd request 90 days.
All right. So I'll take a date 90 days out. All right. So we'll set the payment of $625 for March 12th. To the city of Lansing. That can be paid in person, online, or by phone. And what you'll have, you can set up your own payment plan until March 12th. As long as it's all paid by March 12th, you should be all set. Anything else for the record in 24-03513, Ms. Wilson?
Not for the people.
Ms. Robinson?
No, Your Honor, thank you.
You should be all set, Mr. Embry. You'll get a notice and payment plan or payment instructions. You should be all set. Thank you for your appearance today.
while she's up, but if we could do the waiver on Anthony real quick so I can release my officers.
All right. All right, so Mr. Anthony, we're ready to call your case. You'll have to put on your video if you have it.
All right. Trying to do it. For some
There
reason,
should be a camera there with a line through it, and you can go ahead.
it says it has like a circle around it. Done speaking or something like that. Your video is stopped.
Can you prompt him to turn the video on?
I just did.
Okay.
All right, there you go. All right. All right, Mr. Anthony, we can see you. You can unmute.
He's already.
We got the video, but we can't.
Buzz talking.
All right, there you go.
I'm muted.
Okay, perfect. All right, so we're on the record in docket 24-02-068. That is People of the State of Michigan versus Maurice Anthony. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Schroeder.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Maurice Anthony, who is present and appearing by Zoom with permission of the court today.
Thank you. And sir, you are Maurice Anthony, is that correct?
Yes.
Okay. And you can hear me all right, Mr. Anthony?
Yes, I can hear you.
All right, thank you. This is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that the defendant will be unconditionally waiving his right to a preliminary exam. The people also unconditionally waive their right to a preliminary exam. We request that the case be bound over as charged and negotiations are to continue in circuit.
All right, and is that a full and fair statement, Ms. Schroeder?
Yes, Your Honor, to the best of my knowledge, yes, that is all correct. Thank
All
you.
right. May I inquire of your client, Mr. Anthony, of his preliminary examination waiver?
You may, Your Honor.
Mr. Anthony, you understand you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Aaron Schroeder. She would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish today to waive your right to a preliminary examination, have this case continued to circuit court where negotiations are going to continue. Is it your wish today to waive your right to a preliminary examination?
Yes.
All right. And Ms. Wilson has previously indicated the people also waive their right to a preliminary examination.
We do, Your Honor. Thank you.
Yeah, I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And then I will provide the documentation for bind over. And then do you want me to inquire, Mr. Anthony, that you have authority to sign for it?
Yes, if you could.
Okay. Mr. Anthony, does Ms. Schroeder have authority to sign the examination waiver documentation on your behalf?
Yes.
All right. Yeah.
Hello, welcome.
All right, I'm in possession of the bind over documentation on docket 24-02-068. It has been signed by all parties. Mr. Anthony has given permission to sign. I'll indicate the examination was waived on today's date. Is there anything else to come to the court's attention before I sign the bind over documentation? Ms. Wilson,
Not for the people.
Ms. Schroeder.
Not for the defense.
All right, Mr. Anthony, your time in district court is done. The case is going on to circuit court where the case will continue. Negotiations are going to continue. You'll get your first date to be present in circuit court from your attorney, Ms. Schroeder. Okay, ma'am? Okay, sir? All right.
Okay.
I will sign the bind over documentation. And you should be all set. Thank you for your appearance today.
Thank you. Okay.
Thank you, Your Honor.
We're all set. Thank you for your appearance today. Ms. Lawton, you're here up for Mr. Welch.
I am.
Right. All right, so we're on the record in docket 24-03507. That is People of the State of Michigan versus Howard Welsh. Will the parties please introduce themselves for the record? Ms. Lawton.
Good morning, Your Honor. Jennifer Lawton on behalf of the people.
Mr. Sartz.
Good morning, Your Honor. Jacob Sartz, a fourth assistant public defender here on behalf of Mr. Welch. Mr. Welch is present at council table. He's seated to my right.
And sir, you are Howard Welsh, is that correct?
Yes, Your Honor.
All right, thank you. This is the time set for a preliminary examination today. Ms. Lawton, how we proceed?
Your Honor, it's my understanding that the defendant will be unconditionally waiving his right to preliminary examination on all counts. People also unconditionally waive their right to preliminary exam. Negotiations will continue in circuit court.
And is that a fair statement, Mr. Sartz?
Yes, Your Honor. Thank you.
May I inquire of your client of the waiver of the preliminary examination with negotiations to continue?
Please, Your Honor. Thank you.
Mr. Welsh, you understand you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Jacob Sartz. He would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish today to waive your right to a preliminary examination, have this case continue to circuit court where negotiations are continuing between counsel. Is it your wish today to waive your right to a preliminary examination?
Yes, Your Honor.
Ms. Lawton, the people also, as previously indicated, the people also waive the right to a preliminary examination.
Yes, Your Honor.
I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And I will provide the preliminary examination documentation for signature. Thank you, Ms. Leggett. I'm in possession of the bind over documentation, which has been signed by all parties for 24-03507. I'll indicate the examination has been waived on today's date. Anything else before I sign the bind over documentation, Ms. Lawton?
Nothing for the people.
Mr. Sartz?
No, Your Honor. Thank you.
All right, your time in district court will be done. You're on to circuit court where you'll get your next date from Attorney Jacob Sartz. All right, sir?
Yes, Your Honor.
All right. I'm going to sign the bind over documentation. And you should be all set. Thank you for your appearance today.
Thank you, Your Honor.
Thank you, Your Honor.
Judge, do you know if we need anyone else? Abby's not in here. Gardner, okay. And she's complete, okay.
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 So we'll put the adjournment on the record for
Yes.
Gardner. Okay.
Oh, yeah, can we do Conley real quick?
Yes. And that's Queen Conley?
Yes.
It's gonna be a waiver of the 21 days.
Okay.
All that paperwork you have for the felony plea is where we gotta start out.
I know.
That's on guard.
Yes.
All right. You're Ms. Conley?
Yeah, Ms. Conley, yes.
All right, so we're on the record in docket 24-03492. That is people of the state of Michigan versus Queen Conley. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Milks.
And good morning, Your Honor. Stephen Mills on behalf of Ms. Conley. Ms. Conley is present and standing to my right.
And ma'am, you are Queen Yasmin Conley, is that correct?
Yasmin.
Okay,
Correct.
thank you. This is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe Ms. Conley is going to be waiving her right to an exam within 21 days. The people also waive their right to an exam within 21 days. The drug court referral process has been started. We're just awaiting for that to be completed.
Is that a fair statement, Mr. Milks?
It is, Your Honor, yes.
Okay. May I inquire of your client, Ms. Conley, of the waiver of the 21-day rule?
Please, thank you.
Ms. Conley, you understand you have a right to preliminary examination within 21 days of your date of arraignment. Preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by attorney Stephen Milks, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish today to waive your right to a prelim within the 21-day period, have this case adjourned. It's really for specialty court processes so that we could get a referral to specialty court. Is it your wish today to waive your right to a prelim within that 21-day period?
Yes, Your Honor.
Ms. Wilson, do the people also waive their right to a prelim within 21 days?
We do, Your Honor. Thank you.
I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made, and we will reset for prelim. What's our time frame?
I'm
You-
thinking 30 days, the way
Okay.
things have been going.
Right. I'd say 30 days on with holidays is
Holidays and then the specialty
kind
court
of
referral on top
fair.
of it.
All right, so let's do 30 or days or more out, whatever we have.
January 9th at 1:30.
All right, we'll set it for January 9th at 1:30. All right, so Ms. Conley, there is a plan, okay? We're waiting to see that for that process to work itself out on and by the January 9th at 1:30 date. That'll give us at least a date to set in the future. We'll set it for January 9th. Anything else for the record? 24-03492, Ms. Wilson.
Not for the people.
Mr. Milks.
No, thank you, sir.
Ms. Conley, you're all set. Thank you for your appearance.
Thank you.
Mr. Mills, could you
1:30.
grab one of those notices for your client, please?
I'm sorry, what?
Grab
You have a
notice.
notice
for your
on
Yeah,
client.
she'll have notice.
I just want to make sure she gets her notice.
Yes,
Stay
thank
on
you.
top of things, man.
Come on, Steve.
I think we're lucky to have Mr. Milks.
I
He's probably want it all over,
I know, well,
and we've got him for at least,
not just in court.
yes.
Yeah.
She only needs
In
one.
his
so I was
imagination.
gonna say I need both of these.
You don't need one. I am
If
losing my
you just
mind.
put the other one on Megan's desk, she'll do her thing.
All right.
Thank
Should I
you, sir.
invoice you guys for this or?
I'm gonna invoice you
Yes.
for all the times I have to find.
I'm gonna
Okay, that's fair.
invoice you for emotional distress.
Then I'll be a joinder.
And then Megan's getting
Mr. Gardner.
Gardner. I wanted to pop out and talk to my victim on that real quick.
Have at it. All right, so, and that'll give Mr. Gardner and Mr. Etheridge a chance. I'll adjourn and we can call me when we're ready on the next set.
All rise.
Thank you. You can be seated. We're looking at
It won't be till like January before it can be
Okay,
sent out.
yeah, that's fine.
Yeah, we gotta start all over with.
Okay.
We have to.
Oh, you mean for Gardner? Yeah, okay.
The other one is with the mix up the circuit court right now.
Yeah, that's, yep.
I just
Don't know what judge is gonna get it.
And yeah, and then the trick is, they've been sending fast, we have to type. we have to type this
Yep.
And get it over there. in
Mhm.
time. And. Yeah,
Mhm.
I have a feeling this one's going to be messy.
Yes.
Kelly just did one that got totally out of control with you and a felony plea that's usually like 17 pages and like 10 minutes is 31 minutes.
Yeah. That wasn't the RNO, was it?
No, it
Oh,
was
okay.
it was a guy who was like competent, but was just barely competent.
Yeah.
Yeah,
And so
Kelly,
he had, like, he didn't really understand a lot of the questions,
Yeah.
but like, so he had like really explain the factual basis. to
Yeah.
these
I
things.
usually type for felony pleas for her because they're usually straightforward, you
Yeah.
know, it's just straight typing.
Yeah.
It's not Q and A or anything. And she's like, yeah, this went way off the rails altogether. I was like, oh, that's bad.
He was like, he had like an IQ of like 71, like, so it's just like right
Yikes.
really there. Yeah.
So I just wanted to let you know that.
Yeah,
would
that's fine.
probably Be then.
What are we looking at for McKinley? Probably January as well.
I'm gonna shove that one in there earlier. That keeps getting.
Yeah.
I don't think his client's gonna wait for the what.
We'll see.
Won't be the first time this is happening. That gigabyte.
Yeah, Fife said earlier is better because his trial for next week got bumped, so he's open right now,
But
but
can't get subpoenas.
that's true. Although I think it's mostly just gonna be officers, so that shouldn't be an issue.
Check with Fife.
Well, he's in the middle of a trial right now. And we hear all about it every day.
I can tell it.
Okay.
It's. Zanny's gonna object it because he's still on vacation. That's all this is about.
I mean,
Well, his
technically,
client is basically locked out of nothing, so. that's all.
right. Was he just straight remanded? I think he has a lot right now.
He's remanded no.
Okay.
He might,
Yeah, all right.
but that's why it's going.
I don't even know that Zane has discovery yet because we just got the sub this week.
Del Martyrs, he's ready. I don't know. if I
Perfect.
forgot.
Yeah.
I forgot if I
Okay.
did or
Yeah.
not.
I know I sent you guys that email.
Yeah.
I started to tell you you were walking out of it.
Yeah, yeah, no.
I know you check your email.
Yep,
all
yep.
the time.
I
Yeah,
think
you
ours
guys-
is good.
Thank you.
Right here.
I'm just gonna run to the restroom real quick before we get started.
Come back in a few minutes. report that I had marked for the plea.
Yeah.
Where'd you put my picture?
She was in the library, but I'm not gonna lie, when I was bringing one of my inmates, I saw her talking to a officer.
Oh, okay. Okay, all right.
She was in the library though.
Okay, thank you.
Know your list with them. Court officer talked to her and put her in the library. Now she was talking to police officer, so they moved her somewhere. But she's still probably in the building. That shit. That's what, I guess that's what prosecutors trying to find out.
No, thank you.
I thought she might not show up.
Yeah, probably, yeah.
Tiger.
Nope.
I think she left.
I think she left, yeah.
Who are you looking for?
My victim.
Oh.
I don't know, it sounds like she's really pissed, so we'll see.
Well, it sounded like she was asking the officer something. Oh, we're not muted. It sounded like she was asking an officer about.
We can submit the packet. Or do I need to start
For
this?
this,
For Garner.
well, you said we needed a whole new one, right? Yeah,
Which one of us needs to start?
I think you do, because I think we need a new case number and stuff from circuit, don't we? And a confirmation with which judge it's going to. Sorry.
All right, so we're on the record in docket 2403-172. That is People of the State of Michigan versus John Michael Gardner. Will the parties please introduce themselves for the record, Ms. Wilson?
Abigail Wilson for the people.
Mr. Etheridge.
Good morning, Your Honor. Attorney Derek Esford, Office of Public Defender, on behalf of Mr. Gardner. Mr. Gardner is in the courtroom standing to my right.
And sir, you are John Michael Gardner, is that correct?
Yes, Your Honor.
All right, thank you. This is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. We're gonna be requesting an adjournment in order to get a new felony plea packet done.
It's for a felony plea. That was I think we previously discussed this.
Yes.
I don't know. We've been adjourning this for good cause.
Oh, have we?
Yeah, so would this be a waiver of the 21-day rule
I
in
think
order
it-
to set up the plea?
I think at this point we would need that, yeah.
Mr. Etheridge.
Yes, Your Honor.
All right. So may I inquire of your client of the waiver of the 21-day rule to get a new date to adjourn this for the plea?
Yes, Your Honor. If I could have a second.
Absolutely. All right, so Mr. Gardner, you understand you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by attorney Derek Etheridge, and he would be present to cross-examine any witnesses or to contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish to waive your right to a prelim within the 21-day period, since we've been working on a just cause, a preliminary examination waiver, to waive it so that we can reset it for a plea, okay? And that plea would be in front of myself. Is it your request today to waive your right to a preliminary examination within the 21-day period so we can reset it for a plea in front of myself?
Yes, Your Honor.
All right. Ms. Wilson, do people also waive their right to a prelim within 21 days?
We do, Your Honor, thank you.
Right. Of the 21. Right, so I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made, and we will adjourn for felony plea. That plea will be taken by this court on
January 9th at 1:30.
January 9th at 9:30.
1:30.
At 1:30. And you recognize, Mr. Gardner and Mr. Etheridge, that the sensing will be done in circuit court. Is that a fair statement?
Yes, Your Honor.
Yes, sir.
Okay. And then Ms. Wilson, you'll be in contact with Ms. Holden even more than you normally are.
More than usual, yes.
To set up that packet.
Yes, that's
All right.
correct.
Anything else for the record in 2403172, Ms. Wilson?
Not for the people.
Mr. Etheridge?
Your Honor, Mr. Gardner would ask the court to consider a bond reduction.
All right. Did you want to make a motion to modify bond at this time on behalf of your client?
Yes, Your Honor, thank you. Your Honor, Mr. Gardner was here prior to, and with an effort to plea. At that time, he got confused because the misdemeanor count that he was pleading to, I had discussed with him that he was pleading to a DV second. When he got here at court that day, Ms. Robinson was covering for me. I had the conflict, and the prosecutor couldn't agree to the DV second. It was changed to an ag DV. So he got confused and a little scared or had some trepidation, and the plea didn't go through. I met with him yesterday at the jail, went over everything with him in much more detail, and I met with him a couple times this morning. It's my understanding his full intent to plead as offered, which is to the 2-year felony as well as an ag DV. I have gone over the factual. This will be a no contest plea. I've gone over that factual basis and highlighted report with him. So he has all intent to plead to those 2 counts, plead no contest to those 2 counts. He's asking the court to consider a bond reduction. It's extremely high. He hasn't been able to pay it as it is set now. He would ask the court to consider a low 10% bond with GPS tether. He's been in jail. He advised me continuously since October 17th to the present date. At the jail, he's participated in CAT substance abuse counseling. He's also been involved or part of the honor dorm and been involved in Kingdom Men, where he's been taking Bible classes and studying family dynamics through them. He is a union bricklayer, although he currently probably does not have a job because he is union. He says that once he gets out, he can get the job, a job back through the union. In terms of where he'd live, I believe he would probably stay at the mission until he gets out or until he's able to get the job back and get income flowing again. He's willing to abide by any bond conditions the court feels is appropriate to ensure safety of the public. He'll take any drunk or counseling for substance abuse. He will go ahead and start getting an assessment if necessary. The court can order the GPS tether for safety of the alleged victim. I don't think this is a situation where the court has to worry about whether or not he'll come back to court. I think he will. So he's asking the court to consider a low 10% bond with appropriate bond conditions and GPS tether. Thank you, Your Honor.
Thank you, Mr. Etheridge. Ms. Wilson.
Thank you, Your Honor. I'd leave it to the court's discretion at this time.
All right. What is the updated address for Mr. Gardner? Is that I've got the East Lansing address. Is that still a good address or?
For Mr. Gardner?
For Mr. Gardner.
I don't know.
Mr. Etheridge.
Now, he advised me that he would likely, when he gets out, have to go to the mission.
I have resources and friends from work where I could, but I would probably take the mission and just go through government funded housing. I know there's a lot of programs I could get into. I know there's the mission, there's
well, we still have until we have the plea, this will be addressed. We still have the 15 year, the 10 year, that's count 1s and counts 2. And I know that there's a much lesser plea involved. So I don't have a problem with a reduction in bond, so to speak, as to what's going to happen. But I'm not going to reduce it to a 10%, which might be a problem. But I'm going to modify bond to, it's set at 20,000 cash surety, which is a high bond, and I'm going to set it to 10,000 cash surety. So that will reduce it to the 10 year, really, the 10 year felony. And then my understanding is the initial plea was a 2-year, I think.
That's still the
Okay,
plea offer is the
alright.
2-year, yeah.
All right, so we'll modify bond to the 10,000 cash or surety. And then once the plea goes through, we can readdress bond, but I'm gonna modify bond to the 10,000 cash surety. Anything else for the record in 2403-172, Ms. Wilson?
Not for the people.
Mr. Etheridge?
No, Your Honor, thank you.
All right, you're all set, Mr. Gardner. Thank you for your
Thank you,
appearance.
Are you adding the Tyler?
Oh,
What else?
yeah, we should add, well,
Wait, hang
Do we
on.
need him to sign too, Your Honor?
yeah, tether was already added. Or
Mr. Garner, hold on a minute.
So it
We gotta
wasn't
sign the
in, it's not in
PV waiver.
JIS,
All
so.
right.
I
So
don't think we're signing anything.
Oh, I thought we were signing.
No.
I just want to make sure that GPS tether is a part with the zone notification or zone notification or victim notification, whichever is preferable. Because it was checked, but it's not on the computer.
Gotcha.
And so I want to make sure that we have GPS. There's an outstanding no contact order with the victim in this matter, and the victim is
Rakisha Davis.
Rakisha Davis. All right. With that understanding, bond is modified to 10,000 cash.
Thank you, Your Honor.
Thank you.
Yeah, we can. I got Del Marker first.
Yeah, milk. It's my case first.
Oh,
Go sit down.
Okay.
You know.
Because I want to.
I'll do your signature. Perfect. Do you know about how far you have?
So it's Stella Martyr? Is that correct, Ms. Robinson?
I believe so.
Judge, it's pronounced Blakely.
I'll let you and Miss Robinson decide which cases.
Oh, she's
Yeah.
far more threatening.
But I think Miss Robinson's already won. So.
That was a long time ago too, Judge.
So I appreciate it.
So we'll do, and Mr. Delamarter is here or?
Yes.
All right, all right. All right, so we're on the record in docket 2403-514. That's People of the State of Michigan versus Mark Delamarter. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson, the people.
Ms. Robinson.
Erin Robinson, Assistant Public Defender for Mrs. Delmarter.
And sir, you are Mark Delamarter, is that correct? Thank you. This is the time set for preliminary examination in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. This is gonna be a misdemeanor plea. Is this method use?
No.
Cocaine, okay. This is gonna be a misdemeanor plea to use of cocaine.
So an amended count 1. One of use of cocaine. That is 1 year and or
2,000.
2,000. Keep telling me that. I'm gonna remember one of these. Pat code,
Pat code is 333.74042A.
all right. Is there any other agreements other than the amended count 1, Ms. Wilson?
There is an agreement to no upfront jail. Is there a 74? No, and that's it.
And is that a fair statement, Ms. Robinson?
It is.
May I inquire of your client of his advice of rights on the misdemeanor plea?
Yes, Your Honor, you may.
All right, Mr. Delmar, you understand you are pleading guilty today to an amended count 1 of use of cocaine, punishable by 1 year and or $2,000. There's an agreement between the attorneys that you receive no upfront jail in the matter, which means if I do something different than that no upfront jail, you'd have the opportunity to withdraw your plea. Do you understand that, sir? All right. You have the following jury trial rights in this misdemeanor plea, and I'll walk you through those. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by attorney Erin Robinson. She would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir? You'd have the right to have the court order any witnesses to appear in your defense. to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim. The plea was a result of any promises other than what's been stated on the record, or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading guilty to the misdemeanor count. Is it your wish today to waive your jury trial rights and plead guilty to misdemeanor use of cocaine, a controlled substance?
Yes, Your Honor.
All right. I'm gonna have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
I'm going to bring your attention, sir, back to November 28, 2024, at the offense location of McCullough Street in the city of Lansing, Ingham County. Were you present at McCullough Street in the city of Lansing on November 28, 2024?
Yes, Your Honor.
And at that time, did you use the controlled substance of cocaine at that time?
Yes,
You did not, and you knew it was cocaine when you were using it.
yes,
You knew it was an illegal substance,
yes.
and you were not using it for any prescribed method. Anything else for the record in docket 24? Anything towards a factual basis in this case, Ms. Wilson?
No, Your Honor, the people are satisfied.
Ms. Robinson?
No, Your Honor.
I find the factual basis to be knowing, voluntarily, and accurately made, and we will refer to probation. So on the fifth, go to the fifth floor, probation's there, and they'll see you, and they'll either set up an appointment or see you then. They'll prepare a report for me to see, okay?
No, I didn't. Thank you, Your Honor. Ms. Robinson did just remind me that upon successful plea sentencing, the balance will be discussed.
Okay, so that would be the fourth offender notice will be dismissed.
That's correct.
Yep.
It does for the misdemeanor.
Yeah.
Just wanted to make sure, safe side, yeah.
Fourth offender notice will be dismissed. All right, so the sentencing date will be
February 13th at 9.
February 13th at 9 o'clock. And upon successful plea and sentencing, any of the habitual offender will be also dismissed. It is based on the misdemeanor plea, but it's good to put that on the record, I believe. So I will see you on February 13th at 9 o'clock, right, sir? All right. Anything else for the record in 24-03514, Ms. Wilson?
Not for the people.
Ms. Robinson?
No, Your Honor, thank you.
You're all set, Mr. Delamarter. We'll see you on February 13th.
Thank you, Ms. Robinson.
No problem.
They're all your cases, Mr. Milks.
I know.
It's a problem child.
So do you have a preference as to how you'd like to proceed with Mr. Blakely or Ms.
Yeah.
Culberson?
Ms. Culberson's being brought up. We can proceed with Mr. Blakely and we'll waive appearances.
All right. Lonnie Blakely.
Perfect.
Okay with that?
Yeah.
Your Honor, may I approach?
You may.
This is for Ms. Culberson. It's going to be a no contest due to lack of memory.
All right. Thank you, Ms. Robinson.
Thank you.
All right, so this is on the record in 20-02438 and 22-02196. Calling them together, but we can address them separately if you choose. That is the people of the state of Michigan versus Lonnie Blakely. Will the parties please identify themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Milks.
And good morning, Your Honor. Stephen Milks on behalf of Mr. Blakely. Mr. Blakely, we're waiving his appearance. He is currently in custody and hold up and lock up here.
All right. Mr. Blakely is currently incarcerated in lockup. This is the time set for preliminary examination. Ms. Wilson, how we proceed?
Thank you, Your Honor. I am waiving Mr. Blakely's appearance. At this time, the people are unable to proceed on both files. We have not been able to make contact with the victim on the 2022 file, and we have not been able to make contact with the victim on the 2020 file since 2020. Despite opening their subpoenas and seeing them, my officers did not appear today, so I cannot proceed under 27C. So at this time, the people are unable to proceed. I expect a motion from the defense.
All right, Mr. Milks.
That is correct, Your Honor. On both files, as people are unable to proceed forward, unable to meet their burden regarding a preliminary examination, we are requesting a dismissal on both files at this time.
All right. And as indicated, the witnesses were subpoenaed today, Ms. Wilson.
That's correct.
All right, so I will grant the motion to dismiss without prejudice concerning Mr. Blakely on both files, 20-02438 and 22-02196. And Mr. Milks, you can indicate for our purposes that these cases are dismissed without prejudice, which means that people could reissue if they choose to, but for our purposes today, the case is dismissed.
Yes, Your Honor. And I will reiterate that him downstairs.
All right.
Would you also please be kind and let the jail staff know that we will not be bringing him up?
I can do that too.
Thank you, sir.
Thank you.
Do we have the,
Here's the first one.
this is on 20-02438. And I will sign the dismissal without prejudice.
The second one has quite a few counts, so give me one moment.
And then we will sign the dismissal on 22-02196. Anything else for the record on either of those files, Ms. Wilson?
No, Your Honor, thank you.
Mr. Milks?
No, thank you, sir.
You're all set.
Oh, yeah, now with our new system, because it's all electronic, when they open it, we get a notification that they opened it and what date and what time they opened it. Can't do that for late witnesses.
That's good. I mean,
Yeah.
that means you can make a record and.
Yes, I can.
Yep.
And I can throw a fit. And have receipts.
If you choose to, that's a lot of fits though.
It is a lot of fits. That's true.
There's one more coming. He's got 7 or 8 counts on this one.
All right, so I'm in possession of counts 1 through 3 on 22-02196. I'll sign that accordingly. Count 4 on the same file
That's all, sir.
and counts 5 and 6 and 7 on the same file. All right, so we're on the record in docket 24-03068. That is People of the State of Michigan versus Takesha Culberson. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Milks.
And good morning, Your Honor. Stephen Milks on behalf of Ms. Culberson. Ms. Culberson is present and standing to my right.
And ma'am, you are Takesha Culberson, is that correct? All right, thank you. This is the time set for a preliminary examination today. Ms. Wilson, how we proceed?
Thank you, Your Honor. It's my understanding that this is going to be a no contest plea due to lack of memory to an amended count 3 of attempted resisting and obstructing a police officer. Upon successful plea and sentencing, the balance of the complaint would be dismissed.
Attempted RNO. And that is a 1 year.
1 year and/or I believe it's 1,000.
Do you have a pack code for that? I think it's the same with an A.
Pack code with a bracket A.
Let's count 375, so it'd be 75081D1A.
Correct.
One, two. All right, so I'll reiterate that for the record. This is a no contest plea for lack of memory. To the amended count 3 of attempted RNO or attempted resisted obstructing. That's a 1 year and or $1,000 with a successful acceptance and plea and sentence to the no contest plea. 1, 2, 4, and the habitual will be dismissed with a as indicated with a plea and with a successful plea and sentence. Is that a fair statement, Mr. Mokes?
It is, Your Honor. And if I may make two brief motions before we go forward.
Sure.
Thank you. Sir, as the court is currently open to the public right now, I will also note that the only people in court are court staff, myself, and my client. I would ask if the court would consider not streaming this. There are some sensitive matters that